Good afternoon, everyone. My name is Alexis Bartholomew, and I'm the Director of Statewide Training at Florida Legal Services. Today, we are here for the second to last session of our 2024 Fair Housing Training Bootcamp. Today, we are going to focus on the Violence Against Women Act in the context of fair housing rights. For those of you who are joining us for the first time in this session, welcome. For those of you who are returning, welcome back. We're very happy to be in community here with you all. As always, I'm going to begin with a little bit of housekeeping. This is being recorded, and a copy of the recording will be sent to all of you who are registered and who are here. That will come automatically in an email from Zoom, not from my email address, but I will pop my email address into the chat. That way, if you don't receive that recording or you need anything else, you can reach out to me directly. Second piece of housekeeping announcements, closed captions. Those are up and running for anybody that does need that extra accessibility. If you're struggling to make sure you can see those, just message me independently and I will try to help you out. Again, I'm going to drop my email into the chat, so if you need a little bit more assistance, email me and I'll try to connect with you throughout the presentation. Third piece of housekeeping announcements are CLE. Each part of the sessions in this training series have been accredited independently for CLE credit through the Florida Bar. So I will announce the unique code for this particular training session at the end of today's lecture. I will also make sure that that is dropped into the chat, and I will also ensure that that CLE code is included in that email from Zoom with the recording. Either way, my email will be in the chat. You can reach out to me for anything that you need. Final piece of housekeeping announcement, my favorite, as always, questions and answers. Please don't be shy. I know it feels sort of wonky when we're on other sides of the computer, but we want to hear from you. So throughout the presentation, please drop your questions into the chat or the Q&A. Our presenters throughout this training series have been very good at monitoring those in live time and sort of bringing your discussion into the presentation, which I think always makes it more exciting for everybody involved. So please don't be shy. Drop your questions in, and we look forward to hearing from you. And so with that being said, I'm going to move into the introductions of who we have here today. I've said this in other sessions, and I'm excited to say it again. We are here in it's a full Florida Legal Services event with me as the host and our speakers being my amazing colleagues here at Florida Legal Services, who I'm honored to work with and honored to share this platform with. We have Erika Recek, who is the Director of Survivor Advocacy at Florida Legal Services. Erika has spent her legal career dedicated to helping survivors of domestic violence with legal issues related to protection orders, family law matters, housing, and consumer law issues. She has worked in legal aid since 2007. Erika joined Florida Legal Services in 2018 and continues to assist survivors of domestic violence while also engaging in systemic impact advocacy for vulnerable populations. Along with Erika, we have Joseph Cordova. Joe is the Fair Housing Project Manager at Florida Legal Services, and he spent the first 2 years of his legal career as an Equal Justice Works Fellow, practicing community lawyering for immigrant families. He has since then transitioned such efforts into housing discrimination enforcement and outreach, where he manages Florida Legal Services Fair Housing Initiative project. Joe has over a decade's experience working with vulnerable populations, performing community development services. So with that being said, I'm going to turn it over to you, Joe and Erika. Thank you so much for doing this. This has been such an awesome training series, and I'm really excited to learn about today's subject from you both.
Hello, everyone, and thanks, Alexis, so much for doing this again with us. So grateful to be here and grateful for our audience. I love seeing that participant list. That number gets so high every time. So thank you, everyone, for attending. So today we're going to talk about the Violence Against Women Act, VAWA protections, and how it overlaps with fair housing protections in public subsidized housing. And then we also have a little bit of conversations of what protections might be available in private housing and how the Fair Housing Act and VAWA will overlap and kind of complement one another so that there might be some potential protections. Why this is important, though, and why we definitely talk more about women than we do men, although the law does apply equally to men and women the same. But 1 in every 3 women and 1 in every man have experienced some type of physical abuse from their intimate partner. And intimate partner violence accounts for 15% of all violent crimes. And 1 in 15 children is exposed to intimate partner violence at home. So the numbers are pretty high as far as this particular subsection of vulnerable population, vulnerable communities. And what we're going to look at today is what is available for people who have been on the receiving end of such abuse and violence. and in putting their lives back together, what hurdles they're going to face and how to get over them. So I'm going to pass this on to Erika and let her do her thing.
Thanks, Joe, and thank you, Alexis, for the opportunity to provide this presentation today. Um, so before I move on to the slides, I will say some of the topics, we could talk about them for quite some time. So I know I'm going to be discussing some relief for domestic violence survivors. You see, this isn't a specific domestic violence presentation with respect to relief for injunctions or anything, but I am going to touch on them just very briefly because some of it may overlap with the housing that we discuss. Similarly, with subsidized housing, we could speak for a long time on that as well, but we will do our best with the time that we have today. So with relief for domestic violence survivors, of course, that there are going to be options through the criminal justice system, and there are also protections, though, for individuals who may not want to engage with a criminal case or contact law enforcement. Survivors should always contact their local domestic violence centers in their counties, and I did put the link in here for the Florida Partnership to End Domestic Violence. There is a provider directory. It is a user-friendly web page where you can click on the county and see the certified domestic violence center in the county. A lot of the centers across the state not only have advocates, but they may have other resources such as counseling. They may also have injunction attorneys on staff that can assist with the injunction, depending on the specific case and the relationship that the individual is in. Injunctions can be an option, though, and there are different types depending on the relationship. There is the injunction for protection against domestic violence, which you'll hear me refer to throughout the presentation. Generally, that's going to be in situations when individuals have children in common, if there's a family relationship where individuals have lived together in the past, spouses. There's also a dating violence injunction when there's a continuing significant relationship that's existed in the past 6 months with an expectation of affection. Stalking injunctions can also provide relief when there's been willful, malicious, repeated following, harassing, cyber stalking. There is also the sexual violence injunction when there are qualifying actions under the statute that have taken place. It could also be sought when someone is about to be released from jail within 90 days before. And there's also the repeat violence injunction where there's been more than one incident, at least one of them within the past 6 months. I will say that in situations specific to landlord-tenant, individuals who may have violent neighbors, in situations where there may not be that domestic violence or intimate partner relationship, a repeat violence injunction may be something that's appropriate, again, depending on the situation. Generally, an individual is going to file the petition with the Office of the Clerk of Court. The petitions are available online too on the Florida Court webpage if an individual wants to get an idea of the information that they're going to need. A lot of the domestic violence centers may also have outreach offices. I know that I work here in Orange County, and Harbor House has an outreach office here in the courthouse as well. The court will assess the immediate and present danger based on the petition ex parte to determine if a temporary injunction should be granted. The hearing should be scheduled at the earliest possible time, but it has to be done within the 15-day period. And at the hearing, the court would determine what type of violence has taken place, if it's meeting the statutory requirements, if there is any sort of an immediate danger. So specifically for domestic violence injunctions, it would look at the imminent fear of violence or whether domestic violence has taken place and whether a permanent injunction order should be granted. When we say permanent, sometimes that can be a little bit misleading because that could be until further order of the court, which means it's a little bit more indefinite, but sometimes it's for a more specific period of time. And I believe on the next slide, we mentioned that the parts of relief that could be granted within the injunction could include the temporary parenting plan, exclusive use and possession over the residence, and temporary financial support as well. So survivors of domestic and sexual violence can face various legal issues associated with the domestic violence. They could face discrimination for bringing in a nuisance into the premises or face some sort of adverse consequences for the criminal acts of their abuser. Sometimes survivors are asked to pay for damages that were caused by the abuser and the property. Sometimes survivors may receive a termination notice for eviction, and now they have to answer for this eviction on future housing applications. Of course, we don't want to let it get that far. We don't want it to get to the point of an eviction actually being, if it's filed, at least not being entered. And we want to make sure that if a survivor is receiving any sort of notices, to communicate with us. That's why I do think that connecting them with the local domestic violence center is important, because if they have an advocate, hopefully they have someone that they can share any notices that they've been receiving. Most of the domestic violence centers do have that relationship with their local legal aides. They know to refer them to the statewide domestic violence hotline, where they might be able to receive some information and guidance with respect to these notices. Unfortunately, sometimes these situations arise because a landlord might be a private landlord, and even though they should know better, they're in the business of renting, sometimes they just don't, and it can take some education of the landlord as well. I know that this presentation is specifically focused on subsidized housing, so one would hope that the local housing authority, or if it's a landlord that is in the business of accepting Section 8 vouchers, is familiar at least with the regulations that they've agreed to comply with. But when a survivor has a subsidized housing lease or property, there may be protections that are available, or there are protections, that are available under the Violence Against Women Act. And Joe will touch on the Fair Housing Act after this section. So the next two slides are, I know that Alexis will share the presentation with you, but it's basically a list of different subsidized housing programs that participate and that will be covered under the Violence Against Women Act. I think that the most common are going to be public housing, Section 8 vouchers, low-income tax credit properties, project-based housing, and vouchers, project-based Section 8, but there is a long list that is covered under the Violence Against Women Act. But on the next slide, under the reauthorization in 2022, there was some additional language, this catch-all provision that includes any other federal housing program providing affordable housing to low and moderate income persons by means of restricted rents or rental assistance, or more generally providing affordable housing opportunities as identified by the appropriate agency through regulations, notices, and other means. And I think that that provides a good baseline for when, if there's any doubt if anything would be covered or not, this catch-all provision should include any federal housing program. So who is protected under the Violence Against Women Act? Even though the name may sound a bit deceptive, it equally protects female and male survivors of domestic violence, dating violence, sexual assault, and stalking. Immediate family of the survivor and any members of the survivor's households are also going to be protected. And VAWA further protects survivors on tribal lands, as well as LGBTQ and immigrant victims. Whenever an individual contacts us about their situation, and if they've already gotten to the point of receiving a notice, we definitely want to let them know to communicate with their landlord about the situation. It's not uncommon that the first notice that the landlord may be receiving about this might be either a complaint from a neighbor. It could be a copy of a police report for an incident that happened on the premises, but they may not have the full details of everything that took place. I think letting the landlord know of everything that has happened on the premises, while it may be an uncomfortable communication to have, is certainly important to at least start that discussion and open the door to what relief is available. I think it's very difficult for a survivor to get relief and get protections when they have not engaged in those communications or provided the information that they need to their landlord. So that's usually the first question is, what is your landlord aware of? What have you made your landlord aware of in this situation? When they are in subsidized housing, and when they're in housing, any sort of housing in general in Florida, I'm sure that the attendees here are familiar with Chapter 83 and the notice requirements when there's a violation under the lease. But there going to be more specific notices. That notice of termination or any notice of any adverse action is going to come with some sort of due process. And of course, it's going to depend on the program that the person is a participant in. But these notices should be very specific. If the notice is very vague of, we got a complaint of something that happened on this date, I don't think that's going to be enough to say this is enough to terminate someone's subsidy. So we're going to want the specific details. If a person is contacting you and letting you know, I've gotten a notice and they're wanting to kick me out, I think it's because there was police presence in my apartment the other day. My boyfriend was arrested. I had an unauthorized guest that was staying with me, but I didn't want him to stay with me. All of these different incidents, there's certainly what I would think sound like VAWA is going to be a form of relief for that individual. So you want to make sure that the landlord is being updated with respect to any sort of the activities that have happened on the premises. They should have received a notice of occupancy rights under VAWA when they signed their lease, but they should also receive it if there's going to be any sort of adverse action that's going to be taken. And HUD Form 5382 is actually the certification of domestic violence that the tenant can provide as a form of self-certification, even if there is no police report, even if they did not actually file an injunction yet. And there could be various reasons why someone chooses to not do a police report or file an injunction. But that self-certification form does ask for the information as to what has happened, why you're requesting the specific relief from the landlord. The VAWA communication should be kept in a separate tenant file. All information should be kept confidential. The landlord really shouldn't be retaliating or taking any adverse action at this point in time. And again, I don't want to jump too far ahead and cover any sort of fair housing topics that Joe is going to cover. But if the landlord violates any rights under the Violence Against Women Act, a complaint with HUD may also be appropriate, not only under VAWA, but under fair housing. So adverse factors that are linked to abuse. A landlord should not use any of the these adverse factors against a survivor. It's not uncommon for a survivor to have been financially abused. We do often hear of situations where the other person had access to my social security number. So now all of these accounts were opened under my name that I had no idea existed. My credit is terrible. I have debt collectors calling me night and day. I know that I won't qualify for housing. Of course, there are going to be some remedies under consumer laws and disputes that can be made once they've pulled their credit reports. There might be poor rental history in their past as well, where there may have been evictions because the other person, again, was financially abusive, did not let the survivor work. Rent would not be paid, and they would often be evicted. And because the person was another adult on the lease or in the home, they had to be named under the lease. There may be some negative criminal history as well. It's not uncommon, specifically with human trafficking, where there may be some incidents of forced criminal activity, where a person is forcing the other person to engage and coercing them into either do crimes that they did not want to do, engage in work that they did not consent to. So it is possible to also, we use the example here of writing bad checks or other fraudulent activity. So again, if it can be documented and shown that all of these issues actually came up because of the abuse, those factors should be something that a person can possibly overcome when they're applying for housing. And under the Violence Against Women Act, with respect to any sort of admission into properties, or if you're applying for a voucher and your application is being denied and you're being deemed ineligible due to some of these factors, you may be able to overcome them under the relief with the Violence Against Women Act, that these factors are specifically linked to abuse, and as such, your application should not be denied. A landlord can ask for evidence to prove that the adverse factor was the direct result of the domestic violence. So if now they've received a police report, if a survivor was actually the one that was accused of the violence, but they were actually the victim, and that can be provided to the landlord, hopefully that person can avoid any sort of eviction. So with some of the VAWA protections and available relief, a survivor again, should not be terminated for serious or repeated lease violations due to an incident of abuse. Individuals do have a right to report, and that is something that actually under VAWA applies to anyone. It protects the tenants, the landlords, guests. You have the ability to report a crime. One cannot be evicted for seeking emergency services to their home. With VAWA, an individual can also seek for the lease to be bifurcated. That person should no longer be here. I'm the survivor, but I feel unsafe continuing to live with this person, but I would like to continue living here. There should be time also to establish eligibility. So if it's a situation where there was one person that was the head of household and the voucher or subsidy is only under that one person's name, there should be time that is provided to allow the other person, the survivor, to establish eligibility for that housing program where they were a recipient and benefiting from the subsidy if it was only under the abuser's name. There can also be emergency transfers to another unit if one is available. And if you have a voucher, I always think Section 8 vouchers are incredibly valuable. We want to make sure we're doing everything to avoid any sort of loss of that voucher, but that could actually be ported to another jurisdiction. So if a person is no longer safe in staying in, say, Orange County, they may be able to move to Fairfax County, Virginia, or another place that they may feel safer in living. So there are protections, obviously, under the Violence Against Women Act, but there are also things that VAWA does not do. VAWA does not guarantee admission into a program. A person still has to otherwise meet the qualifications. Just as an example, if there were other criminal acts in someone's history or background that were not related to the abuse, then that may not be something that can be overcome as part of the eligibility. Public housing, I believe, still has the exclusion with any sort of meth-related criminal activity. So if that is the case, then that likely may be something that you cannot overcome, especially if it's not related to that domestic violence. It does not change existing housing eligibility requirements or establish any sort of automatic preference. There may be some local jurisdictions that have a preference list based on their occupancy handbooks, but there's not a guarantee that you are going to be at the top of the list. It does not guarantee protection from any eviction. It just protects against the eviction for matters related to that domestic violence. So if a tenant engages in criminal activity or commits other lease violations, if now you are a survivor of domestic violence, but you are engaging in activity or you're harassing your neighbor, if that's not related to the incidents that you experienced, you're still going to likely be in violation of your own lease. Despite a tenant's status as a survivor and requesting for VAWA protections, a landlord may still enforce the lease to ensure peaceful enjoyment for other tenants. So the owner should have, you can't just say, there's been an incident and now having you here is just a threat to the rest of the community. We cannot continue providing you housing, and this is actually a threat for the community. If a landlord is going to take that position, there has to be some sort of objective words, gestures, actions, or something else that has indicated that this is an actual threat. Actual and imminent threat is a physical danger that is real, not something that we're speculating on. It has to actually have an immediate time frame that could actually result in death or serious bodily harm. And eviction should really only be used when there are no alternative actions or remedies that are otherwise available.
All right, so now we'll take a look at how the Fair Housing Act might overlap with situations of domestic violence and DV survivors. So first, we're going to look at it through the lens of gender or sex-based discrimination protections. Because the overwhelming majority of domestic violence survivors and sexual assault victims are women, they are protected by the Federal Fair Housing Act prohibition on sex discrimination. However, it's not as black and white as I am a domestic violence survivor, I am a woman, therefore you cannot use this against me. You have to go through a little bit of a maze under the disparate impact theory of protection. So disparate impact, we've talked about this in the previous weeks, but Disparate impact is a policy that appears neutral on its face, but has a negative impact on, for example, DV survivors because of its discriminatory effect on women. And underneath the disparate impact, there are actually a few different situations where this might come up. So, for example, housing providers are expected to make exceptions to the zero tolerance crime policy for DV survivors to avoid disparate impact on women. This is something that HUD is really paying attention to. I've gotten some word from the people who manage our grants from HUD and said, keep your eye out for zero tolerance crime communities. A lot of apartment communities, housing providers will try to advertise as we are zero tolerance as a way to promote safe living for future applicants and tenants. But what they're really doing is they're denying housing through disparate impact theory. How this affects DV survivors is that if a landlord or a housing provider evicts a tenant for repeated phone calls to the police for domestic violence incidents because of noise disturbances that are reported by other tenants. Well, all the survivor is doing is exercising his or her rights, in this specific example, we would say her rights for sex-based discrimination, in seeking safety. Calling 911 for safety is not a crime. You might be involved in a crime that's happening, but you are the victim of that crime. But a landlord that simply says you violated the noise disturbance rules of our community, and that's why you're being evicted, that would be an example of disparate impact, because the more you enforce the noise disturbance policy in that situation, more often than not, you're evicting female tenants. Another example is if a landlord evicts a tenant because of property damage caused by the abuse. So you have a policy, zero tolerance policy for property damage in the unit, but the damage occurred due to the abuse and everyone's getting evicted. Once again, implementing that policy is going to have a disparate impact on female tenants. This one comes up quite often. This is a phone call I get from a lot of advocates and a lot of clients. If a landlord charges a higher security deposit to a female DV survivor because the landlord believes she will most likely cause property damage. So something in that arrest record shows that she was involved in a DV incident. Like Erika mentioned perfectly, a lot of times the arrest record will identify the survivor as, unfortunately recognize them as an initiator or a participant in the violent activity, when in reality, they are the victim or the survivor of that abuse. If a landlord sees that on a background check and says, sure, we'll rent to you, but we're going to charge you a higher security deposit because you're more of a risk, that's going to be disparate impact, because implementing that policy, you're going to do that more often to female survivors than you are male. And then similarly, you're denied housing because the landlord fears reconciliation with the abuser. If a landlord says, no, I know your type, you're just going to get back together with him, and then you're going to do what you did at that other place, you're going to do that to my place here, so I don't want that to happen. Again, it's going to impact more women than it does men. As far as where the Fair Housing Act and DV can overlap with disability-based protections, oops, there we go. It is quite common that disability-based protection for DV survivors will come up. So emotional mental health disabilities that stem from the domestic violence, PTSD, panic and anxiety attacks, extreme insomnia, fear in and out of the home. If this rises to the level of a disability, and remember, I think 2 or 3 weeks ago, we talked about what's defined as a disability under the Fair Housing Act is any sort of, major life activity, an impediment to a major life activity. So a substantial impediment to a major life activity, eating, sleeping, drinking, working, anything like that, it qualifies as properly defined under the Fair Housing Act. So if a survivor is able to get a letter from a doctor, a therapist, and I've said this before, and I really think this is an important thing for the people in our community to really push, is that if my letter comes from an advocate from a women's shelter or DV Advocacy, I believe that should count. It's not necessarily clearly written into the Fair Housing Act, but I've talked to some housing providers. I've had presentations with the people at petscreening.com, for example, who do the emotional support animal screenings. And they say that they will accept letters from DV Advocate Services. Best bet, though, is that if you can only get a letter written by somebody from an advocate service center, try to have it be written by the person as high up the chain of command as possible. That letter needs to be written on letterhead and signed. And let's be honest, the more initials after that person's name in the signature, the better, as far as qualifying as a professional recommending that a emotional support animal or reasonable accommodation is needed. So it doesn't always have to be from a medical doctor, but it does need to be from a professional. You can also qualify under the disability under fair housing if there's physical disability that stems from that abuse. This does come up and accommodations might be needed from there. I mentioned this before, a lot of DV survivors are in the need of emotional support animals. And so now you're qualifying under disability. Your disability might be coming from domestic violence, but now you are one of those protected classes. And one of the most common needs that comes up in our world, and remember, when we talk about fair housing protections under the 7 protected classes, we're no longer just talking about public housing. This is public and private housing. If you have a disability and you are in need of a reasonable accommodation, this applies to all housing. And so the most common need that we hear, or at least I hear, is survivors needing an early termination of their lease. We live together, and now I need to be early terminated from my lease because of this DV incident. Maybe I can't pay the rent on my own. Maybe I'm terrified of living here. Maybe the children saw the domestic violence and it brings up too many bad memories for them. The list goes on for why somebody would need an early termination of lease. And as long as you can connect it to a disability, you can make that request as a reasonable accommodation protected by the Fair Housing Act. This comes up quite a bit. We'll talk about this now, and I think we'll talk about it a little bit later, is Erika had mentioned that you can bifurcate a lease under VAWA protections in public housing. But if it's private housing, a landlord is not necessarily obligated to bifurcate a lease because a lease is a signed contract with 2 parties. And if one party goes to the landlord and says, I want you to take their name off the lease, the landlord is saying, well, I can't just do that because one of the parties tells me to. I actually have to have a recognition that there has been a breach of this lease. And so what we often tell people is that if the domestic violence occurred in the home or in the unit, that's going to be a violation of most leases under criminal activity that occurred inside the home or on the premises while an active lease was occurring. So because most leases will say a violation or non-compliance qualifies under criminal activity, domestic violence is criminal activity. So if there's evidence of this criminal activity, the survivor can go to the landlord and say, the contract has been breached by the other party. I need you to take them off the lease. The landlord now has a lawful opportunity to say, yes, this contract has been breached, and I can remove their name or I can end and early terminate this lease. Another way that this can happen is, let's say that the domestic violence did not occur on the premises, okay? Well, like Erika had mentioned earlier, if the survivor gets an injunction, so there's now a restraining order against the other tenant or against the abuser, and the abuser violates by simply coming back around to the home that they live in, once again, the landlord now has an opportunity to say, you have breached our lease because by violating the injunction, you have participated in criminal activity, and therefore, I can recognize you as being non-compliant under the terms of this lease. So early termination of lease can be tricky, but it is available under fair housing protections.
Can I hop in for?
Yeah, I want you to, please.
So 2 things I was going to mention. Briefly with the disability stemming from abuse, I will just use a real life example that I can think of when this came up. The abuse happened actually in a different county in a case that I had. The landlord would have had no way of knowing this incident happened. It didn't happen on the premises. It was someone that the person was, I don't believe they were even on the lease. It was a dating relationship. But the landlord had no way of knowing the DV had happened. But the landlord knew someone was now continuously staying on the property. And in the landlord's eyes, you have an unauthorized occupant and what is happening in the situation. What the landlord did not know is that there was such a horrible, abusive situation that required hospitalization and then also required the individual to have a family member staying at the premises to help them in their care and ongoing recuperation from that horrible domestic violence that they experienced. There was a criminal case. The documentation was easy to provide, but it was a situation where the landlord just didn't know. And keeping those lines of communication open, which again, in that situation, the client was recovering from domestic violence. I don't think let my landlord know about this was really on the top of their list. But you want to make sure that they are communicating with the landlord, because that was something we could easily rectify. And obviously the person had a valid reason to request a reasonable accommodation to have this other individual stay with them while they were recovering from this incident. With respect to the termination of the lease, I do think that it becomes an easier when there's a temporary injunction, you have a non-final order. There's still going to be a hearing date that's set, but hopefully if it was the temporary relief was granted, it also provided exclusive use and possession over the residence. So that way, legally, that person should not be coming, or else everyone has the right to call the police and have that person arrested if they're in violation of that injunction. However, I think that a landlord does feel a little more comfortable, at least in my experience, in proceeding with the request for removing someone from a lease, especially if that person has no legal basis and is actually going to be violating the law if they return to the premises because an injunction was granted, and they may be in agreement with being released from the lease. They may be okay with that, the tenant survivor maintaining possession. And at that point, if that tenant survivor no longer feels safe in staying there, and if they have, I think it's, if a criminal report on its face tells you everything that happened, I don't think that I think it's harder for a landlord to come at us with a straight face and say, I don't think so. However, I think in those situations where maybe there is no criminal report, but there is an injunction, and the participant or the survivor has worked with a domestic violence center, they've sought counseling, or they have other documentation stating this is not the PTSD is being, triggered every time that they're walking into their kitchen because they relive the incident, or any specifics that actually show why this person cannot continue to stay there. I think that it makes it easier once there is some sort of court order that has concluded the person's ability to return. I think I did have an incident recently where someone was saying, well, I don't know if we can really do that because we would have to give access to the person if they came back. But I don't think they realized if they come back, they're actually in violation of the law and should not be anywhere near here, and police should be called immediately. So I just wanted to share that.
No, thank you so much. And along these same lines, we have a great question in the chat. I'll read it aloud and see what answers we have. So, what happens if the abuser is arrested and it is no longer safe for the victim to remain at the apartment, but rent is due prior to the move and the victim can't afford the rent due, not being the breadwinner in the relationship? Is the victim not still obligated to pay the rent owed since he or she is on the lease, especially if the abuser has not paid? Then a follow-up question, can the landlord go after one or both later for the rent despite a proper move? What are your thoughts
So
on
I
that?
think if it's going to depend on well, in part, it's going to depend on if we're talking about subsidized housing versus private housing, because when it's subsidized, if someone is no longer in the home, then that rent should go ahead and be recalculated. You should definitely be letting your housing provider know so that way they can do a recertification, know what the portions of the rent that are going to be paid, especially if it's a voucher. If that abuser's income was being used to calculate the rent and they were the primary wage earner, then absolutely we should be letting the housing authority know immediately so that way they can make any necessary calculations. If the rent has already been due and then the domestic violence has happened, and if all the parties sign the lease and I see a message that says private, then generally it's joint and several liability for parties that have signed the lease, meaning that the landlord can go after either party for those amounts. What I think it's going to also depend on the landlord. And I also think if you happen to come across a landlord that has properties in other states, and in those states they have more tenant friendly laws that they've incorporated into their lease. Obviously, that's not always going to happen, and you're not always going to be fortunate enough to find those situations. But I think that makes the communications easier when you're negotiating with the corporate office. But if you're speaking to your local landlord, again, sometimes it's going to depend on the landlord. They might be more interested in regaining possession over the premises without having to hire their attorney to get possession back, and it may be something where something can be negotiated. I have had situations where a survivor has indicated that they cannot pay the rent, but they've also told me they have nowhere else to go. And for their circumstances, they don't feel like they could go to a local domestic violence shelter. Um, I also think that it's one of those situations where if the landlord also has a right to continue receiving income for their property. So if we're going to propose something, hopefully we can propose something that may be reasonable for both parties. If we're trying to do a move out agreement to say whatever we're stipulating to, but you will have possession over the premises back by a specific date. But under the contract, under the lease, if both parties sign the lease, both parties are going to be on the hook for those amounts under the lease while you're still there. It may be something that, obviously if you're current on rent, if you have the ability to vacate, if all of the boxes are being checked, you may be able to go ahead and negotiate that move out without any sort of lease penalties under the lease for early termination. I know
Yeah,
that's not
and
an exact answer to your situation, Courtney.
well, and I would also jump in. So if it's private housing and you're trying to also say there is a reasonable accommodation needed under the Fair Housing Act, so disability based. So let's say there's emotional trauma, mental health trauma that stems from it, and the survivor says, I can't live here anymore because of all these other things that are going on, not to mention I can't pay the rent, okay? The request to early terminate qualifies as a reasonable accommodation based on a disability. I often have to remind a lot of tenants, is it reasonable to ask a landlord to waive previously unpaid rent? So let's say you're behind on rent a month or two and you're asking the landlord to early terminate. And the landlord says, I'll allow for that because that's a reasonable accommodation based on the emotional trauma you've gone through, and I won't penalize you for an early termination. But you still owe me the month or two that you're late on. And it's not reasonable to ask me to waive that. Some landlords might say it's fine, on whatever, I'll move on. But is it a reasonable request to say, I want you to let me live here for a couple months rent free? That's where we cross that line of what is that reasonable accommodation you're asking.
And I will say, if we're just talking about money, but I'm able to move out, don't file an eviction against me. Like if
Yeah.
we're talking about a monetary dispute, there are other cases that can be filed because that eviction is going to have those long lasting consequences. And again, you may be able to explain the cause for the eviction. When individuals are applying, even if we're not talking about VAWA and having an administrative proceeding when you're being denied, and as Joseph mentioned, we've provided presentations to, he's provided presentations to pet finders. We have also jointly provided presentations to housing providers. And what we always tell them is engage in these communications with prospective tenants. And sometimes you hear about some policies that they have and you're like, I don't know if that's necessarily a proper policy to have. Obviously we're not your attorney, but if you have someone who's coming to you and saying, look, I know I'm applying for housing here, I have the support, I have new employment, I'm able to afford this going forward, but I have to disclose to you that in the past I have had I have a history of domestic violence against me. I was not able to work. I was financially abused. I'm in the process of fixing my credit and disputing some accounts. I also had this last eviction, but that coincided with the time I was getting an injunction. Um, Again, whatever the survivor is comfortable in disclosing, I would encourage that. And in presentations that we've given to housing providers, we've encouraged them to be receptive to these conversations, because if someone is telling you, I can afford the rent going forward, or now I have a housing voucher and I will be able to afford this rent, but I do have these blemishes in my history because of situations that were outside of my control, then I think that hopefully the landlord is able to evaluate this and also see this is someone who should be protected under the Fair Housing Act. It seems that they should be able to afford things going forward. We don't have this blanket policy. And if we do, hopefully we'll reevaluate this blanket policy that seems to have a disparate impact on DV survivors. So for example, if your policy is we only accept people with a credit score of higher than this amount, but a DV survivor may not be able to meet that, then that might be a situation where we take a look at that a little bit more to see if there may be a way to still get that tenant perspective potentially accepted.
And we have a little follow-up here from Courtney. So a disability can be momentary, like emotional based on the circumstances to qualify for reasonable accommodation. So when you look at disability-based accommodation under the Fair Housing Act, you're asking, is the disability an impediment to a major life activity? Well, if my disability is extreme PTSD, panic attacks, anxiety attacks, everything like that, because living in this unit means I am too terrified to go outdoors without all of those symptoms coming up, and I have it diagnosed by a doctor or a therapist, or somebody is able to write a letter saying that their disability is this, and that disability prevents them from even going outside of their unit, meaning they can't go to work, they can't go grocery shopping, they can't live their life. That would be a major life activity that is being stopped due to the disability. If the prescription is to no longer be in that unit, and a lot of that fear and anxiety, PTSD would go away because they're no longer having to relive the moments or go outside, it's not necessarily a matter of the disability being momentary, it's being that the disability is circumstantial to that specific unit. So yes, that would qualify as long as you have the proper paper trail to say, this is my disability as explained by my doctor or therapist, and this is the accommodation that I need.
And I will say, I think, Joe, one of my favorite examples that you've given more recently has been with respect to disabilities. They're not always going to be visible, and I don't think that it's the landlord's position to say, you are disabled, you clearly qualify for this, or you don't know what a person is asking for. So one of the examples that, Joe, I've heard you use recently is, what if a person is coming to you and requesting an assigned parking space at an apartment complex, but if the landlord is just saying no, like, why? You have no impediments with your ability to, I've seen you running outside in the daytime and you have no reason to not be able to just walk to your parking spot, and denying it flat out. A landlord can't do that, and there should always be more investigation and engagement in that process as to why is this necessary. What the landlord may not know is that this person was a victim of a sexual attack in a parking lot at night, and now they get triggered every time they're walking, and they would appreciate the closest spot to their unit because that limits the amount of time and that distance to walking to their apartment. So a landlord doesn't know. So I think if there's any sort of disability or any sort of limitation in the ability of that person to fully enjoy the premises, even if it is from the moment they're parking in their housing, I think that certainly is worth the investigation and the communication.
Definitely. Thank you. Yeah, definitely. And one more thing I will add to that is landlords have to respond. I have a case right now where all these scenarios that we're talking about now came up for a person, and she provided a proper notice landlord saying, due to being the victim of a sexual assault in my unit and on the premises, I'm requesting an early termination. And they just didn't respond. Well, a non-response counts as a denial, okay? So in my particular situation, when the client said, response or not, for my safety, I have to get out of here, and left, going back to what Erika said earlier, the housing provider filed an eviction on them. Even though they left, there was no one left to evict. Obviously, they filed that eviction because they wanted a court record that showed this person was evicted, and it might be easier to go after them for unpaid rents or something like that. But I saw that more as retaliation. You don't have to evict somebody when they gave you proper notice of an accommodation. You didn't respond. And then when you noticed a week or two later that no one was living there, you simply filed for an eviction to simply get that paper trail. We're really encouraging housing providers to not do stuff like that. It's not necessary. All right, so this takes us to our little scenario here. We've talked a lot about this, but we want to hear from you guys. You're welcome to unmute yourselves, or I guess you ask Alexis to be unmuted, maybe jump in the chat room. But here's the scenario. We want to see your guys' responses. So Eva and Clay are unmarried partners living together in a rental unit. Both of their names are on the lease. Clay becomes abusive and Eva goes to the landlord to report the abuse and request that the locks get changed and Clay be removed from the lease. So the first question is, can the landlord act on this information? Let's just do that first question first. Can the landlord act on this information?
And folks, yeah, feel free to jump into the chat with this. If you do want to speak out loud, just raise your hand and I'll see you on the participant list and I will unmute you.
All right. So far I see a no in the chat. Anyone else want to jump in? I think at this point, the landlord is, like you said, Courtney, no, I need more information. Right now, the landlord can't simply say, oh, this happened to you, you got it. Changing the locks right away, he's off the lease, no problem. The landlord needs more information. So the next question is, if not, why not? And what will be needed first? What do you need to know? So what are some things that the landlord would need to know and be sure of before the landlord can act in Eva's favor? Police report, maybe witnesses.
And I think information that we might be missing too is what kind of housing is there here in this situation, because if it's subsidized housing, then there may be other relief that's available, but of course it may be something where we need more documentation, a self-certification form, before we can expect any sort of other additional action or relief.
Yeah, like Erika had mentioned, we've mentioned this in other sessions, we do these presentations for housing providers, and it's really easy in those conversations to look at it through the lens of the housing provider. And if I'm in a room of housing providers and they're asking me similar questions, they're doing it on behalf of, well, how do we protect ourselves? And the answer is have the paperwork. Ask for that police report, make sure things are in people's files. Because if he's simply, if this landlord just evicts Clay right away, removed from the lease, and then Clay comes back and says, hey, you believed one party without ever doing an investigation or getting a paper trail, Clay might have a case against the landlord. So as much as the scenario might be urgent, it's actually in the housing provider's best interest to say, I understand the urgency of the situation. We're going to do everything we can for you, but we can't act simply because you came to us with, your side of the story or something like that. So that's why it's always best to plan ahead to get that paperwork, file those injunctions, get those police reports and everything. Then the last question is eventually what can be done and what can Eva request? So once the landlord has everything in their possession, what is it that Eva can actually be requesting? Well, I guess we can jump in. If it's public housing, you're asking for bifurcation of lease, removal to a different unit, and all that kind of stuff, everything Erika went over. And if it's private housing, what you're really going to be seeking is some sort of early termination, but you have to be able to qualify under a fair housing protected class. So there's different rules for different types of housing. And Erika, did you want to jump in?
I was just going to mention, I think, again, our relief is going to depend on the type of housing that we're evaluating. And because I agree, I think, we may see it from one side of the lens, but obviously a landlord doesn't want to be on the other side where now they're responsible and liable for a prohibited practice of changing the locks on one person. They can't do that either. And I mean, that's certainly something that we tell survivors. And, this is where Chapter 83, what that may allow and relief that could be available depending on the circumstances. I think it's important to note too that, and I maybe should have addressed this more with the injunctions and the relief, but there are specific actions that are going to lead to an injunction. And we certainly speak to survivors of domestic violence that identify as survivors of domestic violence, and we are not going to minimize their experience or say that they have not experienced something that is domestic abuse, but it may not rise to the level where police are actually going to be charging someone. It may not rise to the level where an injunction might be granted. So again, we have to evaluate what relief is actually available for the survivor, connecting with them with local resources like the domestic violence shelters, and evaluating what relief might be available based on their particular situation. So we certainly try to look at it from the and I'm speaking right now, not necessarily just as a housing attorney, but someone who works with the domestic violence survivors. And a lot of our cases with Florida Legal Services come through the statewide domestic violence legal hotline. So as we're, myself and my colleagues are looking at cases, we're looking at it from the whole, try to step 10 feet back and look at the whole picture, because it's definitely going to impact various issues.
Well, and I would imagine, and we have another question, but real quick. I imagine in that world, last week we talked about immigrant community and how a lot of immigrant communities don't want to rock the boat when it comes to filing complaints and moving forward with exercising their rights. I'm imagining in the world of DV coming forward, especially if it means bifurcating a lease or something like that. You're going to have a lot of immigrant communities, especially undocumented people, say, I don't want to do a thing about this. I'm just going to adapt my life. And I'm guessing it comes with a lot of coaching and a lot of coming back. Are you doing okay? So what might be seen as urgent to one person might not be acted upon for months in a lot of other people's circumstances. We have a question here. Oh, go ahead. Nope. Okay, we have a question. I remember you saying in a previous presentation that the landlord can't ignore the complaint, but must still look into it. Does that mean warning against the behavior or just documenting the complaints? A little bit of both. So if I come to my landlord and say, I am being abused, the landlord is probably going to say, I don't want to get involved in that. That sounds like it's between you. If a crime is happening, I will call the police. But as far as getting involved in your guys' relationship, a landlord doesn't have to go into the whole he said, she said, you need to stop doing this, you need to stop doing that. Unless it's tenant on tenant harassment in the form of, it's harassment from another tenant in another unit, the landlord might have to get in and come up with a plan. Most landlords are not going to get involved in someone's relationship and say, then you guys need to break up or you guys need to separate or something like that. Most landlords are going to be within their rights to simply say, if this rises to the level of a safety concern, I will call the police. If there's some sort of fair housing violation of harassment going on, I will investigate the matter and we may have to discipline one party of the situation. For the most part, they are going to create a paper trail of what was happening and what they did. Because domestic violence falls under that category of safety, they're within their rights to call the police once they're alerted to the situation. Did you have anything to add to that, Erika? Or?
Not the specific issue, but one topic I was going to say we did not cover in this presentation, but I think it's worth noting is that obviously domestic violence survivors, especially if there's a situation with financial abuse where they can't pay the rent, they're going to be vulnerable. And if you're adding on layers of, now I'm an undocumented immigrant that's been controlled and coerced, and in this situation where I didn't have a voice and I have no financial means to pay, there's going to be even more vulnerability and more opportunity for a bad actor, such as a landlord, specifically a private landlord, who may try to take advantage of the situation. Sexual harassment in housing is illegal. It is something that I know that attorneys, the U.S. Attorney's Office actively looks at those cases as well. But that is something that, if it's happening, can certainly also be something that we can evaluate under discrimination based under sex. And it could be something that also could lead to a HUD complaint as well. And if you ever get any indication of that, and I feel like we hear that more with immigrant communities, domestic violence survivors, please, of course, give them our information if it's something that your agencies don't cover. Joseph put up here the domestic violence legal hotline. That is something that individuals can contact. We do offer legal advice for survivors of domestic violence, and we can certainly direct them to our other projects where we handle other victims of crime. And I know the next slide has our fair housing information as well.
Yep, that's my information there. That's my number. That's my email address. So people are always welcome to reach out. I know it's 1 o'clock now, but if there are other questions, I'm happy to stick around and answer any. And I know, Alexis, you want to do your thing with the CLA numbers, so I'll pass it back to you.
Of course. Thank you so much, Erika and Joe. In the meantime, while I'm filling up some airtime and you're thinking of any additional questions you might want to ask, I am going to drop the CLE code into the chat. That CLE code is 240453, 5N as in Nancy. one general CLE credit, and then we have some certification credits as well. Again, that CLE code will be included in an email from Zoom along with this recording, so don't worry if you don't jot it down now. Additionally, I did promise to put my email into the chat, and I realized I did not put my email into the chat. I apologize for that. Going to drop my email into the chat right now. It is alexis.bartholomew@floridalegal.org. You will also receive a copy of this PowerPoint in PDF form that will include the contact information that you see on the screen and on the previous slide as well. And with that being said, it's 1 o'clock, and I do see a question that came in. Joe, do you want me to read out loud?
Sure, please.
Awesome. All right, and thank you, Kara, for your question. The question is, have you seen a situation in which the abuser is the minor teenage child and the parent is the sole caregiver? The child is dangerous and mentally unstable, though continues to be released from mental health facilities and will not submit to long-term treatment. This may be a situation in which an eviction may be the only option for the landlord. The parent cannot legally give up parental duties. Oof. That's complex. Any thoughts?
Yeah, I mean, I think from the landlord's perspective, let's say the landlord is the nicest person in the world and really, really wants to help out, but it does just cross that line of safety. The landlord is going to have a right to say, a crime is happening in the unit and it's happening by a member of your household. I'm going to have to move forward with an eviction. But is it private housing? Is it public housing? Like, what is the situation? As far as rights go for I guess this would be private housing. Erika, do you have thoughts on any rights for is it the mother in this one?
I think that a reasonable accommodation request can certainly be appropriate depending on the circumstances and the mental health and, evaluating what may be appropriate. But I also think if the landlord can actually point to an actual and imminent threat to the rest of the community, I mean, if the violence is between parent and child, where now there are noise complaints from the neighbors, I think there may be a balance with that, but also part of the reasonable accommodation. Maybe there's a mental health illness. I understand that there are policies within the complex for, noise disturbances or whatever the situation may be, but it's not something that should hopefully lead to a termination. If it's something where this person who may be abusive is now posing a threat to the neighbors, is verbally or physically abusive, or I think I had a situation once, not necessarily a fair housing matter, but an unruly child was setting things on fire on the community, and obviously that's not something that the landlord has to stick around and watch how it'll turn out. So I think that might be a difficult situation, but depending again on what is happening, there may be reasonable accommodations that may be appropriate.
Yeah, the tricky part here is, again, that word reasonable accommodation. If the mother came forward and said, please don't evict me, I'm asking for reasonable accommodation on behalf of my son who suffers from a disability, and you say, okay, your son has a disability, mental health, it's properly documented, yes, the disability exists for a member of your household, therefore the household is protected. But what is the accommodation you seek? I seek to allow him to commit battery against me and violate the law inside of our unit. Now the landlord might say, well, that's no longer reasonable. I can't accommodate someone to break the law, knowingly break the law inside of my unit. So that's where that line of reasonable accommodation might be crossed. How often it occurs, how intense it occurs, everything like that. That's where that word reasonable can be gray and possibly work out some sort of situation, exactly like Erika said. If it's a noise disturbance, that might be a reasonable accommodation. If it's other types of issues that can be accommodated, yes. But going back to what we said earlier on another one of these, disability, if I ask my landlord to reasonably accommodate me smoking marijuana because of my disability, well, that's a violation of federal law. It's not reasonable to ask a landlord to say, let me violate federal law inside of my unit. So if battery against another household member is a felony, the landlord might say it's not reasonable to let that happen inside of my unit. So that's where it can get really, really tricky. I mean, beyond that, I'm thinking it's going to be more like family law as far as parental duties, parental rights, and everything like that is concerned.
And if the issue is how often law enforcement is coming, again, that shouldn't
Yeah.
be something that the household is being penalized for
Right.
contacting law enforcement just because you need some intervention, because that is a right that someone has to do. But again, I think obviously we'd want to have more details and see what options the person may have, because I know that that's a difficult situation. And as a parent, I doubt that the parent is trying to prosecute the child. They just want to get the child the help that they need.
Yeah.
So in this
Well,
situation, there likely wouldn't be a criminal case, or there may be, I don't know.
and what this would trigger is that interactive process. If you're asking for an accommodation based on the disability and the landlord says it's not reasonable what you're asking me to allow for, they still have to say, well, let's figure it out though. There's an interactive process that says, how can we get to a yes? What is an accommodation that is reasonable that I can allow for that at least helps your situation? It's not a black and white yes or no. It needs to be, let's figure out the maybe, let's figure out the yes. And if they absolutely cannot get to a yes, then the landlord might have a legitimate business purpose to deny a reasonable accommodation request.
Awesome. Well, thank you both so much. As Kiara said, very insightful, and also echoed thank yous.
Yeah.
So with that being said, rounding that 1 o'clock, and I'm sure you both are tired of talking and have plenty that you need to do as well. We appreciate you being a part of this training initiative and sharing your knowledge with us. And I appreciate all of you who take your time out of your schedule as well to come and listen to the trainings that we have to provide. As you can see, they're incredibly meaningful. And Erika and Joe, just thank you so much for all that you do in the community on these fronts and for sharing your education with us here at the Statewide Training Initiative.
Thank you so much for having us. And thanks again to everybody
Thank you
joining
for
us.
having
We
us.
really appreciate it.
All right, everyone. So we will see you at the next event, which is our last event on May 28th. That will be Fairness for Families. And that will wrap up our 2024 Fair Housing Bootcamp. So see you all there. And until then, have a great rest of your week and day.
Thank you.
Bye, everyone.
Bye.